Hi, I'm Christina Blacklaws and I've been specialising in family law for over 20 years. I know that splitting up is a difficult time, both emotionally and practically. Understanding exactly how you're going to address questions like how to protect your home, who should live in it, how you and your ex-partner should arrange your finances in the future, and where any children will live. This will mean you can keep disruption to a minimum. Everybody's situation is different, so it's advisable to use professional help to work out the best way ahead for your own circumstances. Despite what many people believe, couples who live together do not have the same rights as those who are married or civil partners. If you and your partner are married or in a civil partnership, you will have some protection to stay in the family home until there has been a formal agreement about what will happen. If the house is owned or rented by one person in the marriage or partnership, it's essential that you seek urgent legal advice about protecting your right to stay in the home before you take steps to legally end the relationship. It's also worth knowing that if you jointly own your home, in most cases your partner or spouse can't sell or remortgage it without your approval. Before entering into your relationship, you and your partner may have arranged a prenuptial agreement or a pre-registration agreement in the case of civil partnerships. If you have, this will be an important starting point for sorting out the finances. Whether or not you have a prenuptial or pre-registration agreement, you should consider seeking some legal advice about how to deal with the financial issues upon a breakdown of a relationship, and the legal principles that apply. Your legal rights as part of an unmarried couple are different to those of married couples. If you and your partner arrange a cohabitation agreement before you break up, this can be very helpful as you start to work out your financial issues. If you do not, you may need some urgent advice about your position. This is particularly the case if your partner owns the family home in their sole name, as you'll not have the same rights as a married person or civil partner to stay there. Whether or not you have a pre-existing agreement, you still need to agree exactly how your future finances are going to be organised. Financial separation for couples that were not married or in a civil partnership are based not on a fair division but on strict legal principles. What you may be entitled to will depend on any legal agreement in place, such as owning a property jointly or in specific shares, rather than rights acquired because you are in a relationship. Most financial issues between separating couples are usually resolved without going to court. People often find the easiest way to reach an agreement is to use professional negotiation or a mediation service. Negotiation can take place directly with the help of a solicitor, or you can use a professional, impartial mediator to help you reach agreement. Making an application to the court should always be a last resort. Whether you decide to try and resolve the financial issues through mediation, negotiation or court, you must do so on the basis of full financial disclosure. This means both you and your ex-partner will need to provide documentary evidence of your financial income and outgoings so that you can be sure any agreement you reach is fair for you both and for the children. Mediation and negotiation can be particularly appropriate if children are involved. Every parent is required to financially support their child even if they're not living with them or seeing them regularly. If you can't reach agreement on levels of child maintenance through mediation or negotiation, in most cases a resident parent can arrange maintenance through the Child Support Agency. The Child Support Agency has set a calculation to work out exactly how much the non-resident parent should pay based on their net income, the number of children, and how many nights they have the children in their care. There are several factors that the court would consider important when deciding what would be a fair settlement. These factors include how long you are married or in a civil partnership, the financial need to support any children, the potential for each person to be financially independent through work. The aim is to achieve financial fairness when taking into account all the circumstances. The starting point is usually an equal split, especially in the case of a long-term marriage or partnership. But quite often, the outcome is not equal if there is a need for one party to have more, for example, because they need to provide a home for any children. Once you're in agreement about how to organise your finances after your breakup, it can also sometimes be a good idea to have a formal agreement with your ex-partner to prevent any disputes arising in the future. This agreement can have different names depending on whether it's one approved by the court or not. You can find more information on specific areas of family law and the law as it relates to couples and cohabitation in our other videos.